Hi, welcome to the Blockchain and Technology Startup Law Show. I'm your host, Anki Kwan. I'm a California attorney, and my firm, Vanguardium Legal, represents blockchain and technology startups. In this episode, we're going to go over 3 key takeaways that we can learn from the SEC's case against Elon Musk. So last week, September 27th, 2018, the SEC sued Elon Musk for violating the federal securities laws because of one tweet that he made on August 7th, 2018. And basically, Elon Musk tweeted that he was going to take Tesla private for $420 a share, and that funding had been secured. The investors were, some were upset about this, and they tweeted that they wanted to remain investors in Tesla. So Musk responded that he would create this fund to keep Tesla private, and current investors can stay invested in a private Tesla. The SEC felt that this tweet was fraudulent, and they sued him for violating the anti-fraud provisions of the securities laws. So on the days leading up to these tweets, Musk did in fact talk to investors about going private, and they did express interest, but they didn't in fact talk about the price per share, and Musk didn't investigate whether a going private transaction was possible, but he did tell his board that he wanted to take Tesla private for $420 a share, and his board gave him the approval to ask shareholders their thoughts on going private. So the day after he had this conversation with the board, he tweeted to his followers, and after that, all this catastrophe had unfolded, and the SEC sued him. They asked the court for very severe consequences against Musk, and this included disgorging any benefits he got from the tweet plus interest. They asked for penalties, and they even asked the court to bar Musk from ever serving as an officer or a director of a public company ever again. So because these consequences were so severe, only 2 days after the SEC filed that lawsuit, Musk decided to settle with the SEC for $20 million. And on that same day, the SEC also charged Tesla for not properly overseeing Musk for another $20 million fine. So the total of $40 million will be put in a fund and will be distributed to investors as part of a court-approved process. So investors who were harmed because of the tweets will be compensated. So you can see that the consequences from something that is very seemingly small can be severe. So I wanted to talk about some takeaways that we can learn from that case, because I think it provides a very good example of some securities laws concepts that we should all keep in mind, especially if you are starting a company or if you want to run a company. And my first takeaway is that the federal securities laws anti-fraud provisions are very easy to trigger. It doesn't require that you make a statement of fact that you know is untrue. As you can see from the situation leading up to the tweets on August 7th, it seemed that Musk may have thought that he would have been successful at securing funding from investors because he talked to investors who were interested in taking Tesla private. And that $420 share price wasn't something that he just thought of out of the blue. It was based on Tesla's share price on August 1st, and it was a 20% premium above that price, which is industry standard. And he just rounded it up $1 because 420 means something else in the marijuana scene, and he thought it was funny. So it didn't seem like Musk created that tweet out of the blue. He even told his board that he wanted to take Tesla private, and his board gave him approval for to ask shareholders their thoughts on their feelings on taking Tesla private. So that led to the August 7th tweet. So he may not have known that that tweet was untrue, but under that provision that the SEC sued him under, he didn't have to know that the statement was actually untrue. If he made that statement recklessly, he will still be found liable for securities laws violations. So because he didn't do the investigation necessary to see whether going private was possible, and he didn't in fact discuss the share price with investors and confirm with investors that they were interested in taking Tesla private, the court could have found him liable for violating the anti-fraud provisions of the Exchange Act. In addition to that, you can violate the anti-fraud provisions if you merely omit any facts that would make a statement either false or otherwise misleading. So for example, if Musk linked to someone else's tweet that said that Tesla was going private, and he didn't clarify that he hadn't actually investigated whether going private was in fact possible, that can also violate the anti-fraud provisions. So as you can see, the anti-fraud provisions are very easy to trigger, and the consequences of triggering the securities laws are severe. The SEC asked for very severe penalties against Musk, including to bar him from ever serving as an officer or director of a public company ever again. That really is the ultimate sanction that the SEC can ask for against a corporate executive, because that's devastating to a corporate executive's career. For example, if the SEC was successful in suing Musk and the court ordered Musk to never serve in a director or officer capacity ever again, he would have had to resign from Tesla, and he would have never been able to serve on any public company's board or as a director of any public company ever again. But not only that, there are rules called the bad actor rules that prohibit companies that are either bad actors or have certain affiliations with bad actors from raising money under certain exemptions of the securities laws. So if you want to raise money by selling a security, you have to either register the offering or find an exemption to registration. But because of these disqualification provisions, a lot of exemptions will end up not being available to that company. So for example, if SpaceX wanted to raise a round of funding, if Musk continued as the CEO, they may have a difficult time doing that, because if the SEC had sued Elon Musk successfully, he would have been considered a bad actor, and SpaceX would have been barred from raising money under certain exemptions to the securities laws under the bad actor rules. And finally, we can learn from this case against Elon Musk that it's very easy to say something that you regret. So when it comes to communicating about something that is in relationship to your company raising money or your company's securities, please be careful about what you say. And if you have questions about whether any statement that you plan to distribute is legal, please consult with a lawyer first before making that statement. You can think about this as squeezing toothpaste out of a tube of toothpaste. After you squeeze it out, it's impossible for you to get it back in. So after August 7th, Musk got counsel, presumably from his general counsel, and he drafted a post on August 13th explaining exactly why he tweeted what he tweeted on August 7th. But at that time, it was too late, and instead of forgiving him for his tweets, the SEC used those statements that he made on August 13th as ammunition against Musk for the recklessness of him making those tweets, and to support their case against him for securities fraud. So before you make those statements that you may otherwise regret, be sure to review them first and ask for help if necessary. I hope you found this video helpful. If you did, please share with someone who you think may benefit from this information. Thank you so much for watching, and I hope you have a fantastic day. Bye.